Hello, everybody, and thank you for joining us for today's webinar, Win-Win Negotiating, Proven Techniques to Achieve a Desirable Business Outcome. My name is Jeff Murphy, and I'm an Associate Director in the BU Alumni Relations, as well as a proud alumnus of the BU Graduate School of Management. Today's webinar is sponsored by the BU Alumni Association and is offered to our 300,000 alumni around the globe. Throughout your career, the BU Alumni Association is committed to helping you define and achieve your professional goals. We aim to do this by providing alumni with access to a series of valuable online tools and social media communities. It's important that we get your opinion on how we're doing, so we very much look forward to receiving your feedback via a survey that will be emailed to you later today. So for those of you that I know are joining us from as far away as California and Washington State, and even Switzerland today, or if you're just down the street on Comm Ave in Alston, please know that we really do value your opinion on this and every program that we offer. Before I introduce today's speaker, we've got some brief housekeeping notes to go over. As you know by now, this webinar is being hosted on the Adobe Connect online meeting platform. If you experience any trouble with the audio or visual portions of this presentation, I'll ask that you please contact Adobe Connect directly, and I'll give you that phone number if you want to jot it down. It's 1-800-422-3623. Today's presentation is being recorded and will soon be made available for on-demand viewing on the BU Alumni Association website, which you can find at www.bu.edu/alumni. Our speaker today is very eager to answer any questions you may have, and you're welcome to submit them throughout the presentation using the question and answer chat box that you should see located just to the right of the slides. You should see it on the right side of your screen this time. We hope to get to as many questions as we can during today's webinar. Now it's my pleasure to introduce our presenter for the day, BU School of Law alumna Lisa Renee Pomerantz. As you might have seen when you registered for this webinar, Lisa has more than 30 years of legal and dispute resolution experience. After graduating from Harvard University and BU Law, Lisa clerked for a federal judge. Following a stint as a litigation attorney, she worked for 15 years as a senior-level in-house counsel for a major corporation. Lisa is a popular keynote speaker at business meetings and conferences and publishes an email newsletter entitled Making the Connection, which I strongly suggest everybody to sign up for after this presentation today. In 2010, the Long Island Business News named Lisa as a recipient of its Top 50 Around 50 Award, and in 2011 as a recipient of its Leadership in Law Award. Lisa has chaired the Suffolk County Bar Association's Alternative Dispute Resolution and Intellectual Property Committees and received the Director's Award in recognition of her service as Alternative Dispute Resolution Committee co-chair. She also received awards of recognition for her contributions to continuing legal education and as Intellectual Property Committee co-chair. Lisa, thank you so much for being here today. We really appreciate your time. I'll go ahead and get your slides up and running.
Okay, thank you so much, Jeff. I'm absolutely delighted to be here. And I recently attended my 35th BU Law School reunion, had a wonderful time there, and think very fondly of BU, especially when I'm back in Boston. So in any event, our topic today is win-win negotiating, proven techniques to achieve a desirable business outcome. And although we're going to be focusing on negotiation in the business context, I think much of what we're going to be talking about today is applicable in other contexts. And before we start, I'm delighted that we have such a great turnout. And I understand we have a lot of geographic diversity, but I always like to know what the background is of those in the audience. So I'd ask you to post the first polling question to get a sense of our audience's backgrounds.
We've got that poll up there and people are chatting back in with their responses. Just wanted to take a second to let you know that some of your audio is a little bit clipped, so I don't know if you might want to maybe adjust your microphone to make it a little bit farther away.
Okay, will do. Is that better?
That sounds great, right? That sounds great. Perfect.
Okay. Okay, so I'm looking at our poll, and it seems that about almost half of our audience is from the business sector, And we have a smattering of responses from other sectors, including other professionals on the line, and interestingly, no students. So with that, let us move on to the next slide. And thank you. So I'm going to start out with a basic question of what are negotiations? And to me, the definition is fairly simple. Negotiations are communications for the purpose of reaching an agreement. And for the purposes of our discussion today, I'd point out that it's not enough to reach any agreement. An agreement is worthless unless the parties are committed and able to abide by it. Therefore, we're talking about communications for the purpose of reaching an agreement that is both workable and durable. And in my view, for that to be the case, an agreement needs to be win-win. So, and also I'd make clear that when we talk about communications, we're not only talking about the words that people use, but we're also talking about nonverbal communication, including body language, tone of voice, etc. And the fact that email lacks tone of voice, body language, etc., makes it we seem to be getting feedback. A mode of communication that is understanding. And also, I think that's why emoticons really serve their purpose in texting. So, what is an agreement? In my view, there are basically two kinds of agreements. One is a blueprint for a successful transaction or relationship, and the other is a durable resolution of a conflict. And in either kind of an agreement, the other purposes that can be served are protection of the party's interests and deterrence of wrongful conduct. So, these are the reasons we do negotiate, either to engage in a transaction or relationship that creates value, or to resolve a problem or dispute. And let's talk for a moment about what we mean by value creation. Value creation means the difference between the cost to the supplier or provider and the value to the purchaser or recipient, taking into account transaction costs. And traditionally, I would say that transaction costs, which include the costs of obtaining information and negotiating the terms of an arrangement, have often been overlooked or underestimated in the business context. However, I think the success of online marketplaces, including eBay, Elance, Amazon, LinkedIn, etc., can be attributed to the fact that they very substantially reduce transaction costs. So, at this point, Jeff, I'd ask, could we post the second poll, please? So here in the second poll, I'm trying to find out from the audience what people find to be the most challenging aspect of negotiation. Would it be developing your strategy, dealing with interpersonal dynamics, or dealing with impasse? So let's give everybody a few minutes to consider that question and place their vote. and interesting to me that the audience finds thus far that the most challenging aspect of negotiating is dealing with impasse, followed by dealing with interpersonal dynamics, and the item receiving the least amount of votes is developing a strategy. So that's especially interesting to me because I think that perhaps developing the strategy is the most important aspect of negotiation, and we'll be talking about that today. So if we could move, can we? Okay, so there are two aspects of negotiation. The first is distributive, which allocates the value created by the transaction between the parties. And some transactions involve what are called zero-sum games, which is that one party's gain is the other party's loss. And a typical example of that would be negotiations between an attorney for an injured party and an insurance company over how much the injured party is going to be paid. So every dollar that the injured party receives is a dollar that the insurance company has to pay. And so there is limited or no opportunity to really achieve a win-win in that kind of situation. The second aspect of negotiation, and this is principally what business transactions are about, are productive or integrative negotiations, the goal of which is to increase the value created by the transaction. Now, I think that it's human nature that most people, even if a transaction has substantial productive potential, most people focus on the distributive. They want to make sure they get their fair share. However, if the focus of a party is on the distributive aspects, in other words, making sure that they get their fair share, that the other side does not take advantage of them, this can have a counterproductive effect on negotiations. Why? The other party will reciprocate and focus on making sure that they are not being taken advantage of, and they get what they perceive as a fair share of the value of the transaction. And the impact of the parties focusing on distributive rather than productive aspects of the transaction is that they fail to maximize the value that can be created in the transaction. So what we'll be talking about today is how can we engage in negotiations to shift the parties' focus from distributive negotiations to integrative or productive negotiations, increasing the value of the transactions and providing more opportunity for win-win outcomes. So, notwithstanding that the audience does not think that developing the right strategy is the most challenging part of negotiations, in my experience, it really can be the most important. So the first step in preparing for negotiations is to recognize the parameters of the negotiating situation. Among the things that needs to be done are preparing an agenda of issues that need to be addressed in the negotiation. And that should be a list not only of what is important to you as a party, but also what is important to the other side. And one of the things that I recommend is that the parties work together to prepare the agenda of issues. And this has several positive effects. First of all, it gets them working together. It makes both parties feel that they are included in the process and that what is important to them is important to the other side. It also helps produce a win-win outcome by ensuring that all necessary issues are addressed. Aside from the question of what issues need to be addressed in the negotiations, there's also the question as to what are the necessary parties to be involved in the negotiations. And there are many circumstances in which the success of a negotiation depends on permission from or participation of a third party. For example, if one party is selling a business to another party, the consent of the landlord may be required. If a franchisee or distributor wants to sell their business, they often have to get the permission of the franchisor or the manufacturer. So if there are other parties whose participation is necessary, then thought has to be given to how and when they are to be included in the negotiations. And I would suggest if those are essential items, that that question be addressed early, and the terms and conditions under which that third party will be giving permission or be willing to give permission need to be determined up front. Another variable for negotiating situations is whether or not they are symmetrical or asymmetrical. And if you had two people who were going into business together, that would likely be symmetrical. However, many business relationships are very asymmetrical. The employment relationship is asymmetrical. The franchisee and franchisor relationship is asymmetrical. When you go to have your car serviced at the dealership, unless you are click or clack, that is an asymmetrical relationship. In other words, one party has much more information or bargaining power than the other. And again, the presence of asymmetry can be counterproductive for negotiations. Why? Because the party who is disadvantaged, who has less information and fewer resources, is likely to be more concerned about protecting themselves and less willing to look for opportunities to make valuable concessions to the other. So what I recommend is if you are facing an asymmetrical situation and you are the party with the information and resources, that you consider sharing information so that the other party feels empowered. So let's move on to other aspects of preparing for negotiations. And I think this is really where the hard work needs to be done. As we discussed, most parties to negotiations naturally focus on what are their own interests and concerns. But it's important not only to identify what those are, but to prioritize those. The second part, which often is overlooked, is to anticipate and or discover the other party's needs, interests, concerns, objections, and culture. And this could be done by independent research or by asking the party about its interests and concerns. And not only will you get valuable information, but the process of asking that question will make the other party feel that you are interested in making sure that they also profit from the transaction. A third aspect is identifying the needs and interests of the relationship. Business relationships need to have mechanisms for the parties to communicate, make decisions, and resolve disputes. So how that is going to take place needs to be considered. Before you go into negotiations, on each issue that is important, you might want to identify a range of solutions that would be acceptable to you, and also think about what range of solutions might be acceptable to the other party. And by doing that, you might be able to identify mutually acceptable options for addressing the issues to ensure that it takes place in a way that's acceptable to both parties and also takes into account the joint needs of the relationship. More on preparing for negotiations. One of the most important variables in negotiations is selecting the right representative. Sometimes when you have negotiations or a dispute between two parties, the people who have been dealing with each other may have developed some personal friction, which impedes the parties' relationship. In that case, maybe they are not the right people to send to the negotiations. Also, sometimes there is what's called an agency problem, where there is a conflict of interest between the person representing a party in negotiations and the interests of the party as a whole. For example, if you have negotiations between the credit manager for one company and the purchasing manager for another, it may be that the credit manager has certain goals that they have to reach, or they're afraid of appearing as a failure. They might have their own reputational interests at stake, and that may impede their ability to be open-minded and flexible in the negotiations. So in selecting a representative, you want to make sure that you are selecting a representative whose interests are aligned with the company's interests and who lacks any kind of hidden agendas. So other criteria for selecting the right representatives are that the person is knowledgeable about the situation and about what the parameters of their negotiating authority is, that they are willing to be flexible, they're willing to be creative, to think of solutions that might better address both parties' needs. It's also important to send somebody to negotiations who actually has authority. There is nothing worse than having the representative have to call back to the office to get permission for something, because the person from whom they're getting permission is not present in the negotiations and is not receiving information firsthand. It's also important that the representative be diplomatic and articulate, and finally, that they be a counterpart to the other party's representative. It's very important that both parties be able to save face in the negotiations. So if one company is sending their president to negotiate, the other party should send a similarly high-ranking executive. We see this in diplomacy all the time, that the question of who somebody meets with when they come to the U.S. really sends a message, if you will. So you always want to send the right message. So let's move on to conducting the negotiations. In my view, one of the most productive things you can do is come up with a very good initial proposal. Rather than have an initial proposal that is at one end of the spectrum and likely to be objectionable to the other party and almost insulting, I suggest coming up with an initial proposal that is fairly close to what you expect a win-win outcome to be. And some of the criteria for an initial proposal, one, that it be timely. I really think it's a good idea to submit a proposal in advance of any meeting so that the other side can review it internally, that it be comprehensive, addressing not only your own issues, the other side's issues, and the issues of the relationship as well. And to give you an example, if, for example, you are some kind of service provider and you're anticipating negotiating a contract to provide services to a company, it's a good idea to include in your proposal a provision that you will protect the confidential information of your customers. Including something that addresses the other side's concerns, again, conveys the message that you care about what is important to them and that you are looking for a win-win outcome. The proposal should also be fairly equitable, presenting solutions likely to be acceptable to both parties. And sometimes in the initial proposal, you can't address all the issues, but to me it's very important that all necessary issues be addressed, that they be identified, stated in neutral fashion. Sometimes in the course of negotiations, people will state issues in terms like, how do we know, or how can we be protected from your abandoning us, or how do we know we won't be screwed over, or something like that. And there are better ways to state those issues, such as how can we create incentives for the project to be completed on budget and in a timely fashion. It's a good idea to present options in the course of negotiation because people like to make choices, and also to identify opportunities for adding value. You might have a proposal in to provide one kind of service, and it could be that the other party is not even aware that there might be some other kind of service that you could offer that would make the transaction more valuable. Let's talk a bit about the interpersonal aspects of negotiating, and many of you thought this was especially challenging. I think it's very important to try to establish that personal bond with the other side. You want to be welcoming, offering a comfortable environment, offer refreshments. People definitely relax and come to trust each other by breaking bread together. On the whole, you want to be prompt, be organized, and be attentive. You want to listen carefully to the other side. So these kind of courtesies, again, create the message to the other side that they are important and you are being attentive to what is important to them. And generally speaking, when you are generous to another party, it's human nature that they will reciprocate to you. So that is the best way of ensuring that your own interests will be addressed, is by addressing the other side's interests. I also think it's a great idea to make an opening statement when there are negotiations. To welcome the people, to be positive that the purpose of these negotiations is to see how we can work together in a productive fashion, propose a joint objective, and suggest how to proceed. You might say we've circulated an agenda of issues that are important to us, and I think we might start with one issue or another. Now, some people might suggest that some kind of icebreaker or small talk is useful at the beginning of negotiations. And I think one has to be careful about that because business people's time is very valuable. Some people are more or less talkative. And so I think that you need to focus on the culture or communication style of the counterparty to determine whether it makes any sense to engage in any small talk. And you also have to be authentic yourself so that you shouldn't do it just for the purpose of putting them at ease. So let's move on to some lists of do's and don'ts that I have assembled for your consideration. And I think it's important to keep in mind as you're negotiating that how people negotiate reflects how they are likely to be in a business relationship. So you do want to put your best foot forward because you definitely do not want the negotiations to adversely affect the prospects for the business relationship or make it such that the other side doesn't want to do business with you. So on the question of whether one should start with the tough or easy issues, my vote goes to starting with the easy issues. First of all, I think it's good to get a quick win. It establishes a framework for how the parties can negotiate together. It makes people feel positive and optimistic. And so I would start with the easy issues. Don't assume in negotiating that you understand the other party correctly. So what's very important is to restate and clarify to make sure that you've understood them correctly. Number one, this will prevent you from misunderstanding. Number two, it demonstrates to the other party that it is important to you that they be heard and understood. I think it's important to confirm agreements on issues as they are reached rather than waiting to document the agreement at the end. Even if people raise issues that seem to be frivolous or unrealistic, it's important not to be dismissive of them. You can do what's called reality testing. You can ask them how that fear that they have might actually materialize, or try to understand the concerns that underlie their expression of concern. It's human nature to react in an angry or judgmental way when the other side is aggressive or makes unacceptable demands. But I think there's much to be said for trying to keep your cool and just respond to the merits of what's being said rather than expressing personal feelings, which again could get in the way. A few more do's and don'ts. Don't yourself be aggressive. Try to be empathetic and reflect an understanding and appreciation of the other side's interests and concerns. Don't be manipulative. This will destroy trust. You should be honest and forthcoming as much as you can. Don't take advantage of the symmetry. Again, this will make the other party feel very defensive and ungenerous. Rather, provide information to the other party so they feel informed and empowered. Try not to be rigid, but to be open-minded and flexible. I think you don't want to come across as dour and humorless. One, it's counterproductive in the negotiations, and two, nobody will want to do business with you anyway. So you want to come across as pleasant and sometimes humorous. A little humor can go a long way in creating a bond between people who are negotiating. You don't want to be culturally clueless. You do want to be sensitive to cultural variations. For example, I worked for a Japanese company for 15 years, and American culture is much more individualistic than Japanese culture, and decisions tend to be made more by consensus. However, I would not assume that everybody from a particular culture is one way or the other, because there are tremendous variations within cultures. Don't be affected. Be yourself. Be authentic. And do what you can not to embarrass the other party. So there's much to be said for allowing the other party to save face. Dealing with impasse. Now we come to something that many of our listeners found very challenging. And from what I've seen, it must be the case that people in business do find impasse challenging, because I frequently find that what happens is that the important issues for an agreement are actually either overlooked or omitted because people can't figure out what to do about them. So, in the course of negotiations, if you do have come across an issue that seems to present an impasse, you can table the issue for later consideration, but don't bypass it completely. Another strategy is to generate options, and this is something you can do with the other side too, is say, let's brainstorm. Okay, you have this concern about receiving the delivery of the goods before the Christmas season. How might we address that concern? Another idea is to ask the other party for suggestions as to how they can address your unmet needs or interests. If you cannot bypass the impasse, it is fine to say that it does not appear that a mutually acceptable agreement is possible. It's better to do that than to plunge headlong into a business transaction or relationship where failure is inevitable because the parties have not considered an important issue. However, there's no reason you can't keep the lines of communication open and say, we seem to be unable to get past this issue. However, we're going to continue to think about it, and we welcome any suggestions that you might have, and we're happy to discuss it again. So, how do we go about concluding negotiations? If no agreement has been reached, again, you want to always be courteous because you never know when you're going to be doing business again. Thank the other party for their efforts, and if it's applicable, offer to resume discussions at a later time. If agreement is reached, I would commit the agreement to writing promptly, accurately, fairly, and comprehensively. There is nothing worse than having sat through negotiations, thinking you have agreement on all issues, and then the draft you receive does not bear close resemblance to what you thought you had. That just creates mistrust and runs the risk of derailing the transaction or business relationship. Sometimes there have been some loose ends that may still need to be resolved. Again, don't bypass them. Try to tie them up. and most importantly, provide mechanisms for ongoing communication, make sure that the parties will be tracking the progress of the transaction, that they have ways to make decisions as the need arises, and also that they include user-friendly mechanisms for resolving disputes. One of those being, I'm a big fan of graceful exits. And I would be absolutely remiss as somebody who works as an arbitrator and mediator if I did not suggest that I think mediation and arbitration are far more expeditious, fair, and cost-effective methods for resolving disputes in the business context. And so at this time, I think we will see if our audience has submitted any questions they'd like to have answered. And I would also encourage everybody to contact me either via my website, via LinkedIn, via my email. It's all posted on the first page, I believe, reflects my contact information. I love to connect with listeners and love to hear from you even after this seminar is over. I also, you can follow me on Twitter at LRPalm. So Jeff, maybe we want to give our audience a few minutes to see if they have any questions that they've submitted or would like to submit.
Yeah, we've got a couple questions that came in already. Lisa, again, thank you for this presentation. We've got a question from Cal. It's fairly long, and I'm going to try to get through it. If you know that the most important or perhaps only issue for the other side is money, and their goal is to maximize the amount of money they can extract from you, would you still recommend making a significant initial proposal that you think is close to where the parties will finally end up?
Okay. Well, first of all, I think that the situations where the only issue is money are few and far between. In the business context, everybody has reputational concerns. They want referrals. They might want publicity. They might be interested in joint ventures. So I don't think that is often the case. But if it is, I still prefer to make an offer that communicates to the other side that I believe resolution is possible. I think if the offer that you make is too low, that you are communicating to the other side that there is a difference of opinion as to the value of whatever is being either sold or compromised. And another option in that case is to bring in a third party if the matter in question is subject to some kind of neutral evaluation. That could be another method for trying to bridge the gap between the two parties.
Great. Diana chatted in with a question that I think you just sort of addressed. I have a feeling that you might give a similar answer, but Diana's question is whether or not you have any recommendations for handling a situation when the other party is actually doing some of those things that you listed on your list of don'ts. You know, they're not being diplomatic, they're not listening, etc.
Okay, what I would try to do, and I've had this situation, and quite frankly, lawyers are among the worst for this, is trying to avoid responding in kind, but to say something like, "You seem awfully distressed. Could you explain to me what is concerning you so much? And if somebody is very emotional, sometimes if you acknowledge their emotion, then they feel that they have been heard. But again, what you want to try to do is to get to the interests behind the scene.
Great. We've got a question that came in from Borja, who coincidentally I think I know from high school from 20 years ago. Borja, if that's you, hello. Borja's question is, what do you recommend for someone to do who entered into an agreement with a provider to learn 1 month into the job that they were grossly overcharged for their services? So entered into an agreement with a provider. 1 month in,
I'm not sure I understand the question.
Yeah, it looks like this is somebody who entered into an agreement with a provider and 1 month in found that they were really being overcharged.
Okay. Well, what I would first do is read your agreement and see what the options are for exiting, for early termination. And then you have to find out if you have any basis for contending possibly that the other side took advantage of you by not sharing necessary information or possibly misleading you. And I would, I have clients in that situation all the time. And so I would approach the other side and try to try to negotiate for a graceful exit from the situation or a negotiated rate if you can find some basis for taking the position that you didn't have, full and accurate information. But I think that's an example of why you want to read things before you sign them.
Great. Kevin's got an interesting question here. Is there ever a time when one should present a take it or leave it position, say with an offer to purchase an item or a service? Should you ever just sort of give that ultimatum?
Of course, if you are negotiating and you really believe that you would not accept a lower number even if something else were thrown in, then you can do that. But before you do that, you should determine what is it's called a BATNA, your best alternative to a negotiated agreement. So if you feel that it would be better not to sell the item than to sell it at a price lower than what is reflected in your offer, you can certainly do that. But there are ways of presenting it to see if there might be a creative way for the other side to add value to you, such as, I really, my budget wouldn't allow me to pay more than that for this item unless I could be sure that it came with a warranty or something like that, so that you look for an opportunity either for you to provide something of additional value or the other side to provide additional value to you to help sort of bridge the gap.
Great, thanks. Chris has chatted in with a question that I'm going to summarize a little bit here. How do you recommend dealing with, you've got a contract with somebody for services and then the other party wants to change some of the terms. Obviously you want to maintain your relationship with that client, but changing the agreement on the go after you've already reached an agreement is obviously difficult. How do you handle a situation like that?
Well, that actually, and by the way, as my malpractice carrier would say, I want to make it clear that I'm giving general information and not advice on specific situations. But I think, especially in today's fast-moving world, that change is something that everybody should expect. So one of the things, if it's the kind of relationship or transaction where change might be anticipated, is that you want to have some mechanism for a change order process. But there is really no point if, for example, your customer no longer needs something that they had committed to buying. There is really not much to be said for insisting that they take it. So in that situation, the customer should come to you and say, we know we committed to buy this, but we no longer need it. So we want to discuss, see how to find a mutually acceptable way to eliminate this item from the contract. And maybe they pay you for the lost profit on that item, or maybe you substitute something for it. But I would urge you to be flexible, because this is part of what happens in doing business.
Great. Michael has written in with a question that about a book that I have heard of but not read. So Lisa, I don't know if you're familiar with a book called Getting the Yes, but Michael's question is...
very much so.
I figured you might be. So in the book, the author refers to positioning bargaining, which is really more of a win-lose approach compared to a normal win-win approach. So I guess, you know, at the end of the day, the question is, when is it appropriate to sort of go with that win-lose approach to position yourself for future efforts?
Okay, so when is it? Well, I'll tell you, there are circumstances. I worked in-house, for example, for a manufacturer that had 200 some odd dealers, okay? And they all had the same agreement. And so sometimes parties, you know, some of our dealers would want exceptions from things. And in those situations where making a concession could be setting a precedent for other similarly situated parties, there are times you just have to be able to say no. But I think there's more than one way to say no. So I think in saying no, you need to explain the interest behind your saying no, why you are saying no, and you also need to acknowledge that you've heard the request.
Great. Well, we're running up on time here. I think we've had a great conversation. I want to thank all of our guests for chatting in with some really fantastic questions. And Lisa, of course, I really want to thank you first and foremost for your time in this webinar. You know, I think that we've really demonstrated that all of our alumni deal with negotiations as part of their lives, whether they're personal or professional. And I think that you really offered some great content. I want to mention quickly, one of the questions was, again, how somebody could sign up for your newsletter. And we've got the screen up right now. Lisa, is the best way for people to follow up with you either by this email address or just by visiting your website, which is listed at the bottom?
That's fine, or they can contact me through LinkedIn. Either way is fine. Or they can call me. I'm happy to talk to anybody.
That's fantastic. It's really great that we've got alumni like you that make themselves so available to other folks. I really appreciate it, and so thank you again.
It's really been my pleasure, and I want to thank the audience for being so participatory and coming up with such great questions.
Yeah, it was great. As I said, my thanks go out to our guests for participating today. I hope you'll plan to join us for our March webinar, which is going to be on entrepreneurship, which we are happy to offer twice actually during the month. We're going to be doing, trying to hit lunchtime hour on East Coast on a Tuesday, and then lunchtime on the West Coast on Thursday. This is going to be part of our first ever BU Alumni Career Week. Alumni Career Week is going to kick off on Monday, March 16th, and will offer more than a dozen professional development events, both online and and in a few cities in the Northeast, including Boston and New York City. You can sign up now for our March webinar and any and all of our Alumni Career Week events by going to our website, again at bu.edu/alumni. And as always, this webinar series is designed to be by BU alumni for BU alumni. If you or any BU alum that you know would be interested in presenting a webinar like Lisa's for the BU Alumni Association, I hope that you'll contact me at the Alumni Relations Office, or you can email me at jtmurphy@bu.edu. Thank you so much, everybody, for your time today. I hope you have a great day or a great evening wherever you might be. Goodbye.